We are diving into a difficult but really crucial topic today. We're talking about accountability in elder care.
That's right. Specifically, looking at legal strategies for severe neglect, sometimes called bedsore law.
And our mission here is to understand how families actually navigate this. How do you get justice when a loved one has been neglected? We're looking at a specific firm, Bedsore Law, and a pretty significant case.
Yeah, a really tough case involving a 92-year-old resident named Lucy. It's, it's a stark example of what can go wrong.
Horribly wrong. She suffered severe mistreatment over 3 years, multiple pressure injuries, getting worse and worse, and even an untreated fracture from a fall they didn't report.
Just awful. The facility clearly failed her, but her family fought back.
And that fight led to a $960,000 settlement, which is
But
quite a number.
it really is. And that figure alone tells you the legal team uncovered something serious, something systemic.
Okay, so let's unpack that. We hear bedsore law. What does that actually mean in practice? How did the lawyers, in this case bedsore law, prove the kind of negligence that warrants almost $1 million?
Well, it's usually built on existing legal ideas like personal injury or medical malpractice. But the key here, what bedsore law focused on, wasn't just one mistake. It was about showing a pattern of failure.
A pattern? How so?
Through the discovery process, digging into the facility's own records, staffing schedules, payroll data showing who was actually working, inspection reports, they built a case showing the facility was, frankly, chronically understaffed.
So not enough people to do the job properly.
Exactly. They argued the facility knew it was operating below the required standards, making neglect almost inevitable. Things like not tuning Lucy regularly to prevent bed sores, or not monitoring her properly after the fall.
So it wasn't just arguing care was missed, it was arguing the system made it impossible to provide good care, a violation of their basic duty.
Precisely. Connecting the dots between management decisions, maybe related to saving money, and the direct harm Lucy suffered. Those severe injuries, the untreated fracture, that's the evidence that they failed to meet the required standard of care, federal standards even.
Right. And that $960,000 settlement covered her medical bills, pain, suffering. But there's also a quote from her daughter, Karen P. She said the fight was really about validation, accountability.
Yeah, that's often just as important as the money, if not more so. Proving that what happened was wrong and shouldn't have happened.
But, pursuing this kind of justice, it sounds incredibly draining. Emotionally, sure, but also financially. How does a family even start that kind of fight when they're already dealing with so much?
That's a huge barrier. And that's where the model of firms like Bedsore Law becomes really important. They understand families can't usually front the costs for a long, complex legal battle.
So how do they make it accessible?
Okay, so first they offer a free confidential consultation. You can talk to them, lay out the situation, understand if you even have a case with no financial risk.
No upfront costs just to find out your options.
Right. And they offer a free case evaluation too. They'll look into the specifics, whether it's about bed sores, falls, even wrongful death again, without adding financial stress.
That initial assessment must be crucial for families.
Absolutely.
Yeah.
And then, crucially, they work on a contingency basis. This is key.
The meaning.
Meaning the family doesn't pay legal fees out of pocket. The firm covers the cost of the investigation, hiring experts, filing suit, all of that. They only get paid if they win or settle the case favorably for the family.
That's the no recovery, no fee policy you hear about.
Exactly. Bedsore Law uses that model. It basically removes the financial risk for the family. If they don't win, the family owes them nothing for their time or the expenses they fronted. It makes justice accessible.
So putting it all together, Lucy's case shows accountability is possible, even for severe systemic neglect. And this contingency model, the free consults, it means families aren't shut out just because they can't afford huge legal bills up front.
Right. And looking bigger picture, these kinds of settlements, they send a message. They force facilities, or rather their owners and management, to actually look hard at their staffing, their procedures. It can push for real change.
It's a powerful tool, even if it's reactive.
Definitely.
But it leaves us with a final thought, doesn't it? Beyond the legal wins, how can we, as advocates, maybe family members, get better at spotting the signs of neglect before it gets this bad? And how do we bridge that gap between a court victory and truly changing the day-to-day reality for vulnerable people?
That's the ongoing challenge. Constant vigilance, better oversight, stronger enforcement.
Yeah,
It all plays a part.
it certainly does. Well, thank you for taking this important, if sobering, deep dive with us today.
Thank you. It's a critical conversation to have.